appearing on behalf of the plaintiff.
Trevor Catone appearing on behalf of defendant.
And Laura Bro appearing on behalf of defendant Celeste Matthews.
All right. The court has scheduled this remote hearing by Zoom technology in accordance with the Michigan Supreme Court Administrative Order 2020-6. In order to ensure public access, the court is live streaming the proceedings on YouTube, as well as recording the proceedings via Zoom technology. No other recordings of this proceeding are permitted without prior court approval. We're here today on Defendant Farmers Insurance Exchange motion for summary disposition regarding Plaintiff Dawn Johnson. I've had an opportunity to view the pleadings, and if you're ready to proceed, you may begin.
Yes, Your Honor. I'm aware that you've read the brief, so I will keep it short. So the defendant farmers filed this motion based on material misrepresentations made by Dawn Johnson. So there's two primary material misrepresentations that we allege. So the first one is so on the application, Dawn Johnson claimed that she sustained injuries to her pain, entire body, bruise on a leg, side, neck, right arm, lower back pain, lower abdominal pain. The application also asks, have you experienced the same or similar injuries prior to the motor vehicle accident? And she claimed no. So since plaintiff filed suit, we are aware that plaintiff has actually made multiple claims for PIP benefits, and some of which are related to injuries that are sustained to her neck and lower back pain, which are the same areas in which she claimed in this application. So we claim that, so this alone is a material misrepresentation. So for it to be a material misrepresentation, it has to be made and it has to be material to the claim. So critically, whether something is material to the claim is whether it is material to the investigation of the claim for benefits. And the case in which we see materiality affirmed most often is honestly this situation where it's prior injuries. So material to these claims is always going to be a claimant's prior medical history, and critical for any of these PIP cases is whether the injuries sustained in the accident were actually sustained in the accident. So if there's evidence that these injuries pre-existed the accident, then that means that those benefits then benefits aren't available. So that was the first basis of misrepresentation that we filed it on. The second one is one of the questions on the application says, have you ever made a claim for benefits related to a motor vehicle accident? Dawn Johnson said no. So Dawn Johnson has actually made multiple claims for PIP benefits. So she made one in 2018. She filed suit for a 2018 motor vehicle accident, and a judgment was entered by Judge Martha Snow in 2019. And she also made a claim for PIP benefits related to a 2022 motor vehicle accident. And in fact, since then I've looked at the more information on that 2022 motor vehicle accident. She actually signed the release, so she signed the release accepting an amount of money in release of her claims for PIP benefits related to that 2022 motor vehicle accident. And something like 7 or 14 days later is when she filled out this application for benefits. So again, the material misrepresentation was a claim made? Yes, it was made in this app. It was made for this application. Did she knowingly make this misrepresentation? It can't really be said that she didn't knowingly make this misrepresentation. She just signed a release less than a month before she submitted this application. So she definitely knew. And third, is it material to the claim? Again, whether someone was involved in other motor vehicle accidents indicates whether or not the injuries they're claiming were sustained in this accident or in a prior accident. So if someone has a history of motor vehicle accidents and a history of injuries, certainly that's material to the investigation of the claim. Certainly that's so altogether. I'll leave it to the court if they have any questions for me, but there's two material misrepresentations. Either of the two material misrepresentations alone classify a reason to dismiss this case. And so if the court disagrees with one of the two but agrees with the other one, the appropriate remedy is still dismissal. And with that, I will end the argument.
All right, in response?
Did Laura want to go? Did you concur or not?
I don't believe she filed a response.
Okay, I did not know. Your Honor,
Go ahead.
it's
Okay.
very interesting. Material to the investigation of the claim. The claim is being, first of all, let's set the record straight. The insurance company that's before you today handled the other cases, so they already knew the answers. All right. They already knew that she was in a prior accident. They knew everything. How did they learn it? Through discovery processes, because we're open and honest with everyone. Otherwise, how else do they have all this information without a discovery going on? Second, has to be material to the investigation, whether she's entitled to benefits or not. Whether she was, so what you're telling me is if you're in a prior car accident, you can't have a new claim. That is not material. Asking someone their name, whether they have who they live with, whether they have insurance, that is material to the claim and whether they're available to no-fault insurance, not whether they had prior injuries or if they were in a motor vehicle accident. Our brief sets it out pretty good. They cited no case law that this is material. They say it's used in every case, but there's no case law cited in his brief that this specific instance is material. If there was, he would have cited 100 cases, but not one case is cited saying that prior car accident is material to the claim or prior injuries are material to the claim. I just read his brief again. I couldn't find anything. So it's non-supported. There's no case law that they presented, and discovery is still going on. Those injuries could be, at the time she filled it out, similar or not. She was pretty specific on her first application. She had a fracture. She put fracture, right? And the second one, it's all general terms, except but not limited to. So the insurance companies are in a way better place. They get to take her deposition. She needs to testify to this. She can explain that it wasn't similar or not. They don't, how does she know? They can't even prove knowing without her testifying, and they haven't provided any testimony. That's where we're going with this. So for those reasons, the MSD should be denied.
Okay, and is there a reply?
Yeah, yes, Your Honor. And if the court has any questions, I'd be more than willing to answer them. First, materiality. The question isn't whether the fraud worked, whether the material misrepresentation benefited her. It's whether it's whether it's material to the investigation itself. Definitely, absolutely. Plaintiff is correct that you are allowed to be in a motor vehicle accident at one time and then later be in a motor vehicle accident and claim benefits there. What you aren't allowed to do is lie about being in it, lie and say you've never been in a motor vehicle accident, you've never made a PIP claim before you claim benefits. So it's not whether the question of materiality. We don't need to go any further here because it's just is it relevant to the investigation of the claim. So the MIPF, and as this court knows, I'll keep it brief, but the MIPF is in this position where the assigned insurer steps in and litigates cases where they don't have a history with this person. This isn't their contracted insured. This is just someone making a claim for benefits and claiming that they have injuries and claiming that they don't have insurance. And part of the deal here is that plaintiffs have to be honest when they file this application for benefits, and they have to be honest in their representations made. Here, plaintiff was not honest in their representations. They claimed that they had no similar injuries prior to the motor vehicle accident, and they claimed that they've never made a claim for PIP benefits. Both of these things are demonstrably true, and both of these things plaintiff knew were true, considering that she signed a release very recently before she even submitted this application, and she's had 2 motor vehicle accidents. Difficult to forget such a thing. And if the court has any questions, more than willing to field those.
All right. May the record reflect I've had an opportunity to listen to oral argument. Plaintiff filed this first amended complaint on August the 12th, 2024, seeking first-party no-fault benefits from Defendant Farmers Insurance Exchange, Auto Owners Insurance Company, and the MAIPF, and auto negligence as to a John Doe, and owner liability as to Defendant Matthews, arising from a motor vehicle accident that occurred on November the 20th, 2023. Plaintiff Matthews was operating a 2019 Kia Soul owned by Brandon Caver. Plaintiff Johnson was a passenger. Defendant John Doe was driving a 2020 Nissan Maxima SUV that was owned by Defendant Matthews. Defendant Farmers Insurance Exchange filed this motion for summary disposition regarding Plaintiff Dawn Johnson pursuant to MCR 2.116 C10 that argues that Plaintiff Johnson made material misrepresentation and is therefore ineligible for benefits under MCL 500.3173A subsection 4. Plaintiff Johnson filed an application for benefits and made material misrepresentations regarding her pre-accident medical history and her pre-PIP claims. According to defendant, Plaintiff Johnson was involved in 2 prior accidents, one in December 23rd, 2017, and one in February 12th, 2020, which resulted in a case before Judge Snow under case number 1900966NF. Defendant Farmers Insurance Exchange has filed this motion. I've had an opportunity to view the plaintiff's response to the motion, and plaintiff argues that there remains a question of fact, that discovery remains open, whether or not these injuries are similar or the same as the injuries that plaintiff claimed in her 2022 accident is a question of fact. However, plaintiff has also included in her application for benefits that she answered no to the question, have you ever made a claim for benefits, payment of medical bills due to an injury that was caused by an automobile accident? Plaintiff answered this question, no. Now, with regards to this argument, plaintiff argues that defendant already had the information. Defendant was the servicing insurer on the prior claim for PIP benefits. However, the statute, which is MCL 500.3173A subsection 4, indicates a person who presents or causes to be presented an oral written statement including computer-generated information as part of or in support of a claim to the Michigan Automobile Insurance Placement Facility or to the insurer to which the claim is assigned under the assigned claims plan for payment or other benefits, knowing that the statement contained false information concerning a fact or thing material to the claim constitutes or commits a fraudulent insurance act under the statute. A claim that contains or is supported by a fraudulent insurance act as prescribed in this subsection is ineligible for payment of PIP benefits. Now, in the Cantler case, the Cantler outlines what has to be shown in order to show a fraudulent insurance act. It indicates that when a person presents or causes to be presented oral or written statement, which is part of or in support of a claim for no-fault benefits, where the claim for benefits was submitted to the MAIPF, and the person must have known that the statement contained false information and the statement contained a fact or thing that is material to the claim. In this case, the parties do not dispute the first 3 claims. that one, there was a claim presented, oral or written, that it was a part to support the claim for no-fault benefits, and that the claim was submitted to the MAIPF or to the insurer assigned by the MAIPF. The question is whether or not plaintiff knowingly made a statement that contained false information, and if so, was the statement concerning a factor or thing that is material to the claim. When I look at the first allegation of material misrepresentation, that is pre-accident medical history, plaintiff in her application for benefits indicated at question 24, before the accident happened, did you have any of the same or similar injuries as you listed in question 20? And in question 20, plaintiff indicated pain in the entire body, but not limited to bruised leg, side, neck, right arm, lower back pain, lower abdomen due to seat belts, and being 9 months pregnant. In the prior application for benefits, which for an accident that occurred on February the 12th, 2022, plaintiff claimed similar injuries. Plaintiff claimed neck pain, shoulder pain, lower back pain, as well as cuts and bleedings and contusion. So when you review both of these documents, it's clear that plaintiff was alleging similar injuries in her 2022 accident as to her 2023 accident. The court finds that plaintiff made material representation as to her pre-medical history. Going on to the second part is that plaintiff denied making any claim for injuries sustained in a motor vehicle accident. That simply is not true. Plaintiff did in fact have an accident on February the 12th, 2022, and filed a lawsuit with regards to injuries sustained in that motor vehicle accident under case number 1900966NF. Plaintiff's claim that she was not involved in any prior accident was material to her claim. Now, plaintiff argues that defendant Farmers Insurance Exchange should have known, but there is nothing in this statute or case law that indicates that a insurer should have known. Plaintiff is required to accurately and honestly complete these applications, and plaintiff has failed to do so. Plaintiff has presented material misrepresentations as it relates to her claims to the defendant, Farmers Insurance Exchange. The court finds there's no genuine issue of material fact, finding that plaintiff is not eligible for benefits under MCL 500.3173A subsection 4. So defendant's motion for summary disposition is granted.
Thank you, Your Honor.
All right, if there's nothing else,
Nope.
And Your Honor, would you like me to submit order to a court?
I do.
All right. Thank you, Your Honor.
Thank
All
you,
right,
Jeff.
have a good day.
You too.
Thank you.